Are medical malpractice cases always classified under civil cases? Attorney Jack O'Donnell explains that. These are all civil cases. The significant difference between a civil and criminal case is in what is called the burden of proof, which in a criminal case, the prosecution must prove, as everyone's heard, by the standard of beyond a reasonable doubt. That means you really have to have eliminated any reasonable doubt that the person was guilty of the crime charges. For a civil case, the burden of proof is what is called the preponderance of the evidence, which is just a fancy way of saying the greater evidence or the weightier evidence. To use a percentage analogy, when I try these cases in front of juries, I have to get their commitment that if we prove that what we say happened more likely than not, that is, even if it's a close call, but if it's 51% likely that what we say is negligent, we don't have to prove that beyond a reasonable doubt. That's a very significant difference. Some people think that is a very easy standard to meet. It's not, because the doctors always have their own expert, and if it's a toss-up, if it's 50-50, you don't win. That's the difference between a criminal and a civil case. The burden of proof is more significant. For a free phone consultation, contact attorney Jack O'Donnell in New Haven, Connecticut at 203-787-8603 or visit his website at www.jackO'DonnellLaw.com.